certify it because that person, you're making him responsible for a particular piece of work. So the other side would like to know, is that person actually that responsible? So you certify that. How do you certify? Just putting that title above that he is the product manager for that particular project gives it the certification that this person is certified to handle it. Yeah, and his designation is such, that is enough. Delivery and installation, the MSAs should specify when a product is delivered, who is responsible for the initial setup. This all can also go in your SOW. From starting of when the product will be installed to when it will start working to when, different timelines of everything is given. I have seen this kind of things usually with different kind of tools when the marketing or the operations takes it up from different vendors and put it in the system. So tools can be like, if they want to analyze the data that is captured through the website. So on the website, there are n number of people who are visiting in a day, right? You want to understand a person stayed on the website for how many minutes. You want to see what is the ratio of male, female. You want to see which time is the peak hours for that particular website. So all of these is under a particular tool. Yeah, and for this tool, when I am taking it from a particular vendor as a service, so there is that you will receive basically it's all on a purchase order where they mention that this is the delivery amount that we're going to take. This is the installation, one-time installation charge that we will take, which is usually waived later in the negotiation part. Just sharing, so you guys can also ask your clients to get it waived off. But this particular part of the agreement is where everything is specified, and it usually will not always come to you in the form of a master service agreement. It might even come to you in the form of a purchase order. A purchase order even doesn't look like a contract, but don't get disturbed if you see it as a purchase order. You can always convert it into a master service agreement. Put all those specifications in the SOW, and create that legal framework in the MSA. Yeah, so that is what the delivery and installation means. Now the clause of scope of work. This is the most important clause under an MSA. And see how it is written. We've taken it up from different agreements. The dash is for the name of the vendor, and the company can be us here. Hereby agrees to collaborate on research related activities and studies pursuant to a SOW. So to this agreement, so here the first thing what they have done is define the SOW. They're saying everything is mentioned pursuant to this SOW. Pursuant means whatever is there in that SOW. We agree to collaborate and research on related activities and such studies. So whatever they are doing, if you want to understand, please refer to the SOW. To this agreement, the SOW shall describe the respective contribution and service of each party. So the SOW can not be only one-sided, it can also be describing the relation of both the sides. Any service provided by one of the parties under this agreement is referred to as service. That is why master service agreement, it is a service agreement. For the purpose of this agreement, the party engaged to perform the services is the performing party, and the one is receiving is services for which are to be engaging party. So you can keep all these quoted ones as reminders for yourself, because at that moment when you're creating you feel confused at times what to name them, because it will appear in the agreement again and again. So I like it how they have defined it, performing and engaging. So the one who's engaged to perform and the one who's supposed to receive has been defined. All SOWs that are negotiated between the parties shall be in writing and executed by the parties and shall be attached to as supplemental exhibits and shall be incorporated into governed by this agreement. Simply it is saying that whatever exhibits are coming as, they are well negotiated and they are the SOWs, and they should be incorporated in this agreement, and they will be governed by the agreement, that is the master service agreement. So now don't get confused when I say that the SOW, you can put a line that the TNCs of the SOW will rule. That's the magical part of this agreement. I would say that, though even the main part of the agreement is the master service agreement, the SOW one-liner allows it to overrule the entire MSA. But of course, this one line will always be found in the MSA, which will say that it will be governed by this agreement. Each SOW will set forth, amongst other things, what is the main constituent of an SOW. A description of the service, responsibility of the parties, estimated timelines, that is your milestones and your timelines, project milestones, deliverables, and detailed budget for the service, that is the payment or the money that would be involved. If a party requests a change for an SOU, they are doing it by way of a change order. You can do it by way of an additional addendum or by way of another exhibit. That is also fine. The change order is not always that. It is the mandate to make a change. Okay, you can do it by that, and you can clearly define what the changes are occurring, from which clause to which clause. Yeah, it says like, which shall identify in reasonable detail a complete summary of whatever the changes, mentioning that if the project was supposed to be in 2 years, but now you're seeing that how the wave it's moving, it can be completed in a year. So you say that this is the change that we are looking at. Impact of the project schedule, maybe from 2 years it has come to 1 year. It's moving fast. Impact on the deliverables have reduced because whatever our project target was, it has been received. And D, the impact on the project's fees. My projection was of 2 crores, but I'm done and done with 1 crore only. For the avoidance of doubt, all change orders are subject to the written approval of the vendor and the company. This is important because you can't leave it without this until and unless if there are changes, and if it is not signed by both the parties, or written approval is that you usually sign it, or they say yeah we agree, whatever. Until and unless you don't take that, it should not become a binding piece of contract, because somebody may just do it for causing a concern to both the sides, which is not a good idea. So signatures or agreement and approvals from both the sides should always be a mandate for any such changes. Yeah. Is there a question?
Yes, Rashna, in the chat, Pranav is asking to elaborate what is statement of work. He's not able to understand.
We will speak about it. We have spoken about it, and we will speak about it at the end. Don't worry. It's a part of the master service agreement, and all the specific part of the project goes under the statement of work. That is your SOW. Yeah. Intellectual property rights and ownership. Very important. Any technology contract that you deal with, it will have an intellectual property right thing. You cannot ever rule it out because it's the whole and soul. It's the main asset of a technology company. And when you're dealing with service and a technology company more so, because everybody is creating something, and when they're creating it, they of course building a lot of IPR under it, right? So whether that IPR is going to belong to you when they create something and pass it on to you, or when they're creating it, it will be retained by them. This is what this clause defines. So usually it is owned by, no, it's not usual. At times it is there when it stays with the person who was creating it, and at times it is with the person to whom you are delivering the project. But an intellectual property right and ownership clause has to be there, just like any other agreement. I'll read this. Explain what result of work on project under individual SOWs are considered intellectual property, as well as who owns the contract deliverables and retains ownership, copyrights and other rights. That is what it is, that who retains those IPR rights, whether it is the copyright of the website, whether it is the different logo or the different tags that you created under a website development, who will own that IPR rights. specify which data and material must be sent to the customer. Meanwhile, the paper must specify which software, invention, technology, data developed prior or during collaboration are the property of the software firm. So of course, whoever is developing that for you, yeah, the software, the invention, the technology, whatever is developed in that, so is that going to be owned by the person who has made it for you, or is it going to be the person for whom you delivered the project? Yeah. So it is actually usually, I would say, maximum time it goes to the person for whom you have delivered it, to whom you are supposed to deliver it. There are very less times when the developer who is making it for any particular service, it stays with them. So this can be a negotiating point. And I would say the party who is a bigger party, actually it stays with them, yeah, because intellectual property nobody wants to part of usually. When there's a software application which is just supposed to be supposedly leased out, then it is always with the developer who has the rights, who has made it. But if the same software is sold out to the person, yeah, then of course the IPR also gets rolled over. So you have to see this clause. If you are just receiving a draft which is in MSA, and if it is defined already that the IPR is going to with the person who is doing that project for you, you will have to see the weight in the level, the leveraging point. It is going to be a negotiating point for all of us. It will not be an easy IP thing here. Yeah, IP will be a part of negotiation almost all the time. Yeah. And the term invention means invention, including without limitation a new use of study, drug or device, and other intellectual. So it is basically, this is taken from some contract which might be dealing with a research MSA, So that is why they are defining under intellectual property, they're defining the term invention, right? Similarly, you can also do it. If you think there's a copyright, when you're developing a website, there will be a copyright. You can define the copyright, right? And you should, but even if you define it, please know that the copyright will be going to the person who owns that website, not the one who develops it, right? Publication, dissemination of study information to the extent not otherwise prohibited by any other agreement between the vendor and the company or an applicable SOW. Company is free to publish or present with respect to studies conducted under this agreement without the prior approval. So now again, this is a particularly based on a research agreement. It's basically a research MSA. So they are putting it how they would like to deal with the dissemination of the study information, which is going to be a part of the research, right? So they're just constricting their rights and saying that here, if this is a particular scenario, we would not need a prior approval of a particular person. That is what it is. Similarly, if you have such a situation where you feel that, okay, whatever I'm doing for the particular person, for that particular company to whom I'm delivering this service, but I want to reserve this right, you can put it under a clause, and maybe, you can always negotiate it. It is not that whatever we say that these are the standard clauses, a particular business may require a particular clause to be developed. You can do it. And are you getting it from this point number 7, what I'm trying to say? Just like the person who has been dealing with this publication or dissemination of the study information, who's studying this, making that research, he says, to the extent not otherwise prohibited by any other agreement between the vendor and the company or by the applicable SOW, the company is free to publish or present with respect to studies conducted under this agreement without the prior approval of the vendor. So what is it here saying? That the company is taking the right that whatever information is collected for this particular research, if it is not prohibited in any other manner, we have the right to publish it and present it for free without taking the prior approval of the vendor. Because it is showing here that it has the authority, and it is showing here that whatever is happening in this, creating this particular project, all of that is mine. Hence, it doesn't require a prior approval. authorship of result of the applicable SOW will be based on the contribution to the SOW and in accordance with the academic standard and custom. That's again very particular in respect of to the particular MSA it is coming from. Okay? It is not a regular or a standard clause, this publication and dissemination. Yeah. Confidentiality means you cannot move without confidentiality. There are agreements before which NDAs are done. That is how important confidentiality is. And if you are working in a technology industry, and if you don't define confidentiality properly, or if you don't take the effort to have an NDA before even executing an agreement, you are putting your client, your organization at stake, because it's too competitive out there. Okay, so define your confidentiality clause very, very, very clearly. You need to put whatever you need to put it, so that the confidentiality clause is defined very clearly. I each time read that confidential clause definition to make sure that I am not missing onto a point. Sometimes the word oral, verbal, written is so important, I can't tell you. Just by putting these three words, you are actually bringing all the information together and binding it by the term of confidentiality. Just oral, verbal is the same and written, right? So must clearly state what information should be considered confidential, right? And not subject to disclosure to public third parties. Can decide for how long. Exceptions, that's always there. The exceptions are a part of the confidentiality clause, which is like if it's already there in the public, or which when you were passing it off to the receiving party was already aware about it, or if there is a statutory order or government order, you have to disclose it. These are the exceptions to the confidentiality clause. Yeah, the MSA must clarify whether the software development vendor can advertise its partnership with the employer. No, usually they don't allow this until and unless the product is announced by the employer. They say you make it, keep it, let's test it, let's launch it. After that, they give them the right that you can put it on your website showing that you've worked with us, or we are in partnership with you, or we are one of your clients. That's fine, but not at the very inception. Yeah, you can put it under confidentiality. So that's about it. Let's move ahead. Project management, declare who is in combined. Please, not limited to one person, at least have two persons. If one person leaves, the another one can take up the responsibility and can be held responsible also in the long run. Because if one leaves, then who is supposed to take care of that project until and unless the other one comes? And if the other one comes, then if the person is not named, then for that period of time, it's very uncertain for that particular document, and it can lead you to real problems. Say that is the time when one person leaves from your company and that project also goes wrong with that vendor. Then how are you going to deal with it? Of course, the CEO can take it, the legal department can take it up. But what about if you have a second person in command? Because the team lead who's leaving as the project manager, there will be another people who will be working with him. They will be far better in command than the legal department or the CEO. Don't you think that? Should it not devolve to the next person in that line rather than it devolving to the CEO or the legal department? So having one or two persons, at least two persons to be named one after the other, and make them aware that your names will go here. Yeah, after you are in line, because a project is not handled by a single person. There are quite a few people who are working together. And if you name it, it can easily devolve, and both the people will be equally responsible, knowing that they need to know the facts because they are answerable in future. And I'm telling you this also out of experience, because if somebody leaves, it becomes very difficult to, think of whom you should put second in line, or if there is anything which has gone wrong with the vendor at the same time, it becomes very difficult to deal with. Because then you will, even if it comes to the legal department, the legal department will also have to join all the dots to actually deal with the issue at hand. But if you put the same person from that particular department, it can be very easily handled, right? So create aligned people. What I'm telling you is, you need to pose it to your clients so that it strikes them like, oh yes, it's a wonderful idea. Even if they don't have many people, they will say, okay, in second in line, put my name. So the agreement will be clear that, okay, if this person is not there, this is the second person to be dealt with. That is what project management manager names are important in an MSA. Yeah, this situation reminds me of one of the cases where we were not in accordance with our MSA and we dealt with a settlement, and I actually remember holding the phone and negotiating. So yeah, don't put yourself in that place where the legal department has to bear all the burden, because the legal department already will have to do a lot of work. So create people in line to avoid such situations. Yeah. Warranties and liabilities. That's we've spoken about. In every agreement that you come with, there is a warranty and a liability. Warranty is assurance. Liability is where I decide that whatever happens, if there is a direct damage, I will bear it up to a certain extent. That is what warranty and liability says, right? Similarly, it will be in the master service agreement. Any agreement will have a warranty and liability. You cannot move without these clauses. Do I need to speak more on this? Are you guys okay? Is it okay till here? Do we have any questions?
I don't see any hands, but I think we should take some questions or pause for a while.
Let's put the screen down. Yeah.